everybody. Couple of logistical things that came up in emails and other things. On the blog, problem? Better? Sorry, my voice is a bit rough today. On the blog, anybody who is unable to post as an author, everyone should be able to comment. If you can't post as an author and you want to, there are maybe a few people who, on the original emails that were sent, didn't send me their campus-wide their email address associated with your campus-wide login. If you sent me another email address, not the one associated with your UBC campus-wide login, you will not get an email authorizing you to be an author on the blog. So, or your student number, either will do. But if you find that you are not getting on, please let me know. And we can figure it out. It's actually pretty easy to figure out. Thanks to our intrepid camera person, Saeed, videos from the first 5 talks should be up on the blog site in the next 2 days. They're just going to be the raw videos, but to the extent that you want to refer back for the purposes of papers to any information, you'll have a little bit more than just the presentations. Speaking of papers, now's the time. Start thinking about them. You don't have to send in or correspond with me about ideas or get your ideas pre-approved, but it is, generally speaking, a really good idea to do so. I've got an office on Wednesdays in the faculty, room 427. Any preference, so I will keep office hours from here on in. Any preference as to whether I keep them right after class, sort of 12:30 to 2, or 2 to 3:30? Those would be the 2 options. Anybody care?
I have a slight preference for afterwards because there's often things going on at lunch.
Okay, so then let's assume that starting today, my office hours I'll confirm it's 427, are 2 to 3:30, and I will put that up on the syllabus on the blog. Yep, 427, I'm at workstation 427A, so all good. Another thing that's come up is the mention, and I know I addressed this last week, but I'll address it again this week, of I look at the blog, it's really interesting. I just get nervous that my comment is too small or may not be relevant. No comment is too small, no comment is not relevant, and all of us together can make any comment large and extremely relevant with a little bit of effort, and that's the idea behind the blog. Okay, on to the talk. I am challenged by Rock to keep this one on time because it has an unprecedented number of slides. So we'll see how we do. Follow-ups on last week. I just loved this. The Museum of Modern Art, which happens to be my favorite art museum in New York, mapped out how different abstract artists were influenced by each other, and that's the map they came up with. You know, when the notes are posted this afternoon, you can go to the site and see how cool it
Is
is.
that ever laid on a geographic map? Like, is that sort of North America in the middle, Europe off to the side, or?
No, that is sphere of influence. So exactly how they mapped it, you'll have to go to the methodology and see, but it's pretty neat. I should have maybe raised this one earlier. This is a tremendously influential paper that is totally worth reading. It was published in Harper's Magazine in 1939 by a great American educator by the name of Abraham Flexner. And it was part of a campaign to get funding, get more funding for the Institute for Advanced Research at Princeton, I think is what the institute is called. That's where Einstein came. And it was it was an institute of academics, not all in one area, working across many disciplines and working cross-culturally. And the issue that some raised is that, a little bit like law schools today, well, this should all be very, very practical. Why are we pouring all this money into things that are impractical? So Flexner's paper deals with that and deals with it very well. But in the course of dealing with it, he makes the point relevant today about how what we think of intellectual property comes to be. And he says, and I'll let you go to the article because it's really worth going to, Marconi and the radio was inevitable. And all the pieces were in place. All the pieces were so-called useless knowledge, worked out by academics and others. All the problems had been solved by Maxwell and by Hertz. And then Marconi came along and invented something that actually rapidly fell into disuse. A now obsolete, this is now obsolete in 1939, receiving device called the coherer. But he got credit. And in our context, would have gotten the intellectual property. But really, knowledge is the process of accreting bits. The institution you're in, the process that we're engaged in today, right now, is the process of accreting bits. So think about that as you think about intellectual property law, as you think about copyright law, and as you think about games and how you play them.
So is this sort of framed in a advocating for academic freedom, for example? And if you have all sorts of people publishing these little bits that are slowly coming out, that you'll have somebody able to invent on them, or?
The issue Flexner was really dealing with at that time was, how do you create this unprecedented institute where you're just going to get a bunch of great brains in very different disciplines all sitting together in one very separate institution in Princeton, New Jersey? And how do you get that funded, and how do you get that rationalized? In doing that, he traveled, but not in a dogmatic way, through all of these issues, including academic freedom. And it's well worth the read. I may actually post a little bit more about it on the blog tonight.
You're killing me with these slides, John. You're killing me.
I am just incompetent.
But I mean, what this is an opposite slide because my undergrad degree is in electrical engineering, so I've studied Maxwell's equations and I built a radio. And it is not obvious how to get to a radio from 4 equations.
Fair comment. I wish Festinger was around to debate it with you. I'm afraid I can't. But he clearly believed it was.
Everything's obvious 100 years after the fact.
Perhaps, yeah, can't argue with that. Okay, this completely inadvertent meme that has arisen in this course around the tie-ins of sort of Nordic freedoms, their attitudes towards IP, their economic success. The meme lives on, and this is just kind of this week's additions to it. Hope you like the picture of snow. How's that for stereotyping? The World Press Freedom Index came out this week, and yet again, there you go, Finland first, Netherlands second, Norway third, and ROC contributed on the blog, Swedish tech startups outdoing European rivals. Just more. Okay, today. This is core stuff. And it's not really 10 cases, 10 clauses, 10 contexts. It's a good name for the talk. It's really the lessons learned to focus on. This is all part of connecting. Next week we'll be talking about connecting through technology. Today we're talking about connecting consumers, gamers, developers, and intellectual property holders on the other side. But what do you look for today? As we go through this, look for the collisions. Look at where things knock into each other. The collisions of contract law and copyright freedoms, expressive freedoms, which are different. So think about all of these as slightly different. Contract hits copyright as a legal concept. Contract hits your right to speak. Contract hits your right to create. Contract collides with your right to connect. So break them down because they are all different, and you will see as we go through the contracts examples of each of them. Look for, as we talk about what courts may or may not have decided, where the courts are interested. Are they interested more in the user and gamer, as the Supreme Court of Canada may have shown a preference for in a larger sense in the pentology? Or are they more interested in the developer and the world outside the game, or the world outside the artificial reality? The world outside the software. So think inside software user, outside software, outside game developer. Think a lot about your first year contracts law course. Think about what contracts are for. Think of how bargains really originate. Are they really original? Are they really individual things? Are they really intended to be collective things? What is a bargain? Can you have the kind of mass bargains? I don't mean legally, because legally you clearly can't. But is the intention around what contracts are meant to be somehow watered down or changed in the world of mass contracts. And think about something that we mentioned, especially last week, I think. The complexity of contracts. Contracts can be infinitely complex in and of themselves. Drafting contracts, creating a contract gives the drafter infinite flexibility. Think of how the infinite flexibility, the infinite sliceability and diceability of intellectual property feeds into that. And then there's one thing I'm not going to ask you to think about now. It may occur to you during the class, but hopefully by the end. Repeat after me. You've all done this. I am agreeing. I am not reading what I am agreeing to. I am doing this thousands of times. Each document I am agreeing to and not reading is different, often quite different from every other document I am agreeing and not reading. We're all doing this. We're all doing this all the time. We are lawyers and law students, and we're doing it all the time. What's happening to non-lawyers and non-law students and non-academics? Do you think we're the ones not reading it and they are? Obviously not. So there's something out of whack here. And solving it is really difficult. So we have arrived at the belly of the beast. That's my picture of the belly. It's the best I could do with copyright cleared free pictures on the net. Okay, cases. There's a lot of words here, but many of these cases we've already dealt with, and I'm just going to whip through and get to the conclusions. Davidson, you know, we keep talking about it. It's the BattleNet case. BNETD or BNetD, as I've learned it should be called, which was put together by a group of Blizzard gamers who were dissatisfied with Blizzard's multiplayer implementation called BattleNet. To do that, they had to sign a EULA and a terms of use. And here are the words. You will not translate, reverse engineer, derive source code, modify, disassemble, decompile, create derivative works based on the program. And you will see in the terms of use one more concept, which is you won't host or provide matchmaking services, which is in fact exactly what BattleNet is, right? It's a matchmaking service that allows single-player games to be played in a multiplayer mode, and was for its time an awesome thing. And it was free, so they weren't charging for it. There were ads on it, but it was free. And BNetD was equally free, an alternative, and whether the developers of BNetD intended it or not, it could play cracked games, whereas the Blizzard version could only play fully authorized games. Now, we've talked about it a number of times in the course in terms of what happened. And you know from the case, which you really must read, that there was a lot of discussion about contract law, and that did not go so well for the BNetD folks. But you also know that the court found breaches of intellectual property statutes that were separate. So there were a number of things in the case. In the case today, we are talking about the contracts. I'm sending you to a fascinating document. Well worth reading all of it, but important to understand for our purposes. It's an amicus curiae brief of a group of law professors. So this will sound like special pleading, I know, but this was a really serious group. And they argued in their brief with comfort and assurance, as they should because they're law professors, that Blizzard's end user license agreement should just be preempted by copyright law. Copyright law is more important than the contract. And the court's decision is exactly the opposite. And that reversal of priority, decide for yourself, but from my perspective, doesn't seem to be explained by the court. So I challenge you in your papers or elsewhere to figure out exactly why a group of pretty august law professors, not all of whom were on the copy left, many of whom were in Silicon Valley, and were in the copy middle, at least, were so certain that contracts should be preempted by copyright law, and why contract, in the end, preempted copyright law. And most importantly, where is the explanation for that? Because I've been looking at this case for 10 years, 7 years, 8 years, and I can't find it.
Sorry, they wanted contract law to be more powerful than copyright law?
No, the professors wanted copyright law to be more powerful than contract law. The court said, no, contract law is more powerful than copyright law. You opt out of copyright law through contract. And that's fine. But can we have an explanation, please? So surely, which means it's not sure at all, a group of law students as august as you will be able to find an explanation for this. I fully accept that law professors can be wrong. I am often wrong. Next case. Blizzard and in-game. We're going to go through the Blizzard cases first for a specific purpose, and one that hopefully will be obvious to you, even on this slide. They keep on changing the wording of their own terms of use and end user license agreements. Even within their own company, they're constantly revising and changing them. And that's normal. And that's actually healthy. Because you when you're in corporate practice, you look at situations that have arisen, and you alter your documentation to suit it. But I do want you to hold the point of this lack of standardization. So obviously, when BNet D arose and they went to court, Blizzard's lawyers got on it and looked for holes in their own agreement. How would we do this better? How would we improve it? So you're going to see different language. But let's focus on in-game dollar. In-game dollar was a gold farming company. So they would farm gold on your behalf and change the dynamics of the game. So this is that larger issue of what's in the game, what's outside the game, what happens with virtual currencies. And we're increasingly going to deal with that as the course goes on. So this is just a teaser of that. But in-game was advertising that if you want more gold for your Blizzard game, that will get you up the charts, come to us and we'll provide it. Blizzard claimed that the problem with this was that it diminished the experience of the gamer. So hold that thought. This wasn't about Blizzard. This was about the gamer. The gamer, in Blizzard's view, wants a level playing field. I don't disagree with that. Different people have different feelings. I don't have any reason to disbelieve in how they conducted this case, that Blizzard wasn't entirely sincere about protecting the integrity of the game. But that's the rationale. In any event, this didn't really go anywhere. Consent order, IGD, the gold farmers closed their doors. That was it. Which takes us to another case we've talked about, because we didn't talk about IGD before. Another Blizzard case, the MDY case, which is the glider bot case. Again, this should be similar to previous EULAs in terms of use. You'll notice subtle differences and not so subtle differences. Bots are a little bit like gold farming, but you're installing them. So you're using a program that is playing the game and accruing credits for you while you're not actually engaged in the game. So this is to benefit the gamer, but it also unbalances the game as far as other gamers go, unless they've also installed a bot. So it does have the effect of fundamentally changing the game. We've talked enough about this case. What I want to refer you to, and I know I've referred you to it before, but now in a little bit more detail, this was the Electronic Frontier Foundation's take on the case. And it shows their anger at how the court upheld the contractual provisions in the license agreement, as the EFF calls it, the magic words in an end user license agreement, slapped onto a consumer product which turns buyers into mere licensees. To the EFF, ownership really matters, and being a mere licensee when you are paying as if you were an owner feels like an injustice, and making the license agreement the ruling document, not copyright, is what they rail on. The good news, as you know from previous discussion, and which is included here, is that whatever may be a problem in terms of the makers of Glider, the court refused to find that a gamer using bots and using Glider was infringing copyright law. So you can start sensing where this is going. And that even in contract law, not perhaps as explicitly as we've seen elsewhere, the notion of users' rights is gelling a bit. Now we have almost the identical case years later, 2010, to the BNet D case. Blizzard and Marshall. I'll invite you on your own time so I can keep my promise to be on time today. You can compare the documents. They're here. Again, it's completely normal. It is what you will do in your career. This shouldn't look like the end user license agreement or the terms of service in the BNet D case, because if it did, what were Blizzard's lawyers doing all that time? But because it doesn't, remember the repeat after me. You're signing tens of thousands of these things, and they are changing all the time. And so maybe it doesn't matter because you're not reading them anyways. Or maybe it should really matter to somebody.
Has anybody ever tried to argue in court that, it's so long, it's just an expectation that you click on it, you're in a hurry to get in the game? And I remember there's the one case that we studied, I think it might have been contracts, and it was where the person was going through the rental car agency at the airport, and they checked a box, and the courts found the rental car agency had the obligation to explain the extra piece, and the person because they were in a hurry, the contract didn't stand. Has anybody ever tried that for video games?
No, the closest that we've got is the Rogers case that I referred to last week, and that is contained in the materials, which is a 2011 BC Supreme Court case that does a pretty good job, a very good job, of running through the various click wrap precedents, and comes to the conclusion that, at least in that case, it's okay. Helen?
I guess my concern with users' rights is there liabilities for the video game makers? Like if a user modifies a game and creates something really violent or uses somebody's trademark or product placement unauthorized, and then that company goes and sells the video game company, like, how do they say, oh, that was just a mod, we didn't do it? And
Well, there are, the question you have to ask yourself is whether all of these contractual rights prevent that, whether if that happened that could be preventable in other ways, and why copyright law in and of itself wouldn't prevent that from happening. So where this is going is to suggest that these contractual provisions might be redundant. Now, having said that, the reality in the video game world is that lots of mods and lots of things that are distasteful are being absolutely let go by the video game companies and even encouraged. I mean, I think the more hardcore FPS people here would acknowledge that they've played some levels in Doom that are not politically correct. And those are not being shut down, even though there are certain contractual rights. Now, you know, not to dwell on it too much, you can narrowly tailor your contractual provisions to deal with the problems that you're describing. They don't have to be 60-page documents to do that. They can actually be a page.
so what you're saying is that these contracts and agreements protect the corporations that make the video games from liability if something's one of their unauthorized modifications.
Well, they govern the relationship, all aspects of the relationship. This isn't just about mods. They govern all aspects of the relationship between the user and the video game maker or the licensor. And they range very, very broadly. And they are not narrowly tailored. And when you, to get away from video games for a minute, it is worth asking why your iTunes agreement, if you've agreed to it, is 99 pages long. And does it need to be? And if it wasn't, what would happen? And in that is a very good paper, if anyone's interested. Okay, so there was more on this. Now here in the Marshall case, this is BNet D number 2. And the facts are that a Blizzard user group created the ability for gamers to play pirated copies of StarCraft 2, which was in beta at the time.
I just wanted to say that the current World of Warcraft license agreement is 8.5 pages.
Okay? They've done a good job. And Microsoft has also taken some steps to make their license agreements much shorter. But what was the I'll research it, but what was the World of Warcraft agreement when it first came out?
You should have asked me 7 years ago.
Exactly. So I think there is increasing sensitivity to the issue, but the World of Warcraft agreement doesn't look like the Doom 3 agreement. And it doesn't even look exactly the same as the StarCraft 2 agreement. So we have these multiple variations. In any event, Blizzard sued, and the lawsuit was dropped a week later, with Blizzard stating the matter has been resolved in a way that has allowed us to dismiss the lawsuit. In other words, the user group stopped doing what they were doing. Case 5 is Werner and Autodesk. This is not a video game case. This is classic, but you have to know this case. It's a classic case of end user license agreements. So Werner bought the Autodesk software and wanted to resell it. So we're not talking about a mod. Autodesk didn't want that right to be associated with they're licensing you the software in their mind. They're not selling it to you. This is the EFF argument. And the court, this is from the court decision, the court upheld the contract and then said it's up to the legislator to do something different. iRacing, again, a case we've talked about. Just wanted you to see the actual lines in the EULA, no derivative work. But I want to talk briefly about a factual problem here. And the factual problem is that the software maker and the game company does like having communities, and communities that get in and behind their game. So iRacing and NASCAR, the NASCAR series before it, and Grand Prix Legends before that, who were all run by the same group, they did more than turn a blind eye to modders. They worked with modders behind the scene. And what happened in the Robinson case is you had a modder who they felt had gone too far. And that may be why the court stopped Robinson to the extent they did. I apologize for this. The only way I could get the court decision, or part of the court decision, was effectively take a picture of it. So it wasn't very malleable. And you will see on the subject of the EULA that the court upheld the EULA in spite of the fact that Robinson claimed that what he was doing wasn't very different from what other groups, other mod groups were doing that iRacing was cooperating with. So again, what you are getting here are an awful lot of snowflakes, an awful lot of very individual situations. Smallwood and NCSoft, this is someone who sued because they claimed they had gotten addicted to Lineage 2. That they became psychologically dependent. And what I want you to note in the decision was that the court properly, but went to some lengths to preserve causes of action in preference to the wording of the license agreement. So again, within the circle of being the gamer, the circle of being the user, there's at least some support. Hernandez is another gold farming case. Now what's interesting about Hernandez is that Hernandez is not a video game company. Hernandez is a video gamer suing a gold farming company for interfering with his game. And he argued that he, as a gamer, was entitled to be a beneficiary of the agreements that IGE, the gold farming company, would have been breaching with the makers of the games. Now, sadly, the case was settled, so we don't know how that would have gone in court. Zynga is a virtual currency case where Zynga sued Nebraska for trademark infringement, but also complained about Nebraska having websites that sold virtual poker chips for its games. Now, when you hold this up to the double standards test, and to go a little bit to Helen's point earlier, here the video game company is protecting its turf because, as we know, Zynga is moving rapidly towards trying to be the first large-scale video game company to get legalized gambling into games. So you can ask yourself, what is this really about? Evany and Holland is a straight out, and we'll be dealing with this later in the course, a straight out clone of an already existing game. And again, in all of these cases, I am focusing, for the purposes of this class, only on the license agreement, although you're about to hear a whole lot more on this subject. Again, I want you to see this because I want you to see that it has differences from all the other terms of use, and the specific language is all slightly different. Default judgment case. Holland never defended, so it's not a real result. There is a decision, there's a judgment, there's even a monetary amount, but it tells us very little. Okay, so I have 10 minutes. To focus on what this magical mystery tour of contractual terms is really all about, because it doesn't tell us a whole lot. It tells us a little bit about the courts being sensitive to gamers and users. So what are we going to conclude? So we've talked a bit about the post-IP world. And I just want to put out to you that there are two possible versions of it. One is the one I put before you last week, which is the end of the world, the end of the IP world is coming through contracts. Making IP all but irrelevant. And you can find some support for that, obviously, notably in the BNetD case. But really, in the real world of contracts, and the fact that most of us are not touching IP, we're touching contracts. We're hitting I agree. And as far as we're concerned, 99% of the time, 99% of our relationship with the gaming company is governed by that contract and not by anything else. And certainly for all practical purposes. And is that right? Is that wrong? Obviously, that's for you to decide. A different version of the post-IP world is the world of the Supreme Court of Canada, and that is the user rights world. Because that also erodes certain understandings of IP. Or you can interpret it as consistent with IP, but it certainly, from a copyright holder's perspective, significantly shrinks their world. So, a couple of observations. Feel free to disagree or push back. If you go through the cases, I think what you'll find is that copyright law and IP law, because it's legislated, is seen by the courts as having serious consequences and being a serious remedy. And contract law, though not, and the licenses, though not unimportant, are seen as a little less consequential. And the evidence of that is clear. It's in the iRacing case. It's in what Rock talked about earlier. It's in the court saying that you have to treat the contract claims and the copyright claims differently. And the copyright claims and the damages are different, and contract will only entitle the claimant essentially to damages. And you can see in how the court treats it that there's a narrowness to contract. But there's the advantage of the drafter, and that's the company. None of us are putting out there, it hasn't gotten to the point of those websites where you can say, if you will get me a mortgage at this rate, I will take it. So none of us as consumers are saying, if you will send me a license agreement on these terms, I will accept it. Which company is going to agree? Okay, Microsoft, you got my business. That's not happening. So there's a definite advantage on the other side and not on the side of the consumer. There's also, and you can look at the Robinson case, you can look at these giant companies and these little, sometimes rogue individuals user groups. And the license agreements are useful to the companies in intimidating consumers that way. And whether intimidation is a fair word or not, I don't know. Substitute it with warning if you prefer. And we come to the point at the beginning, and that is, and the point that we discussed in the class, and that is the click wrap fiction. And right now, I can find no strong evidence for you that the courts are not upholding that fiction. And it's uncomfortable because we all know that we're not reading it. And I'd love, and it's not obviously possible, and it's obviously not proper, but I'd love to be able to do a survey of judges in the world and see if they're reading their click wrap agreements. Maybe they are. And even if you do read them, what choice do you have? It's another part of this that, you know, gets mentioned, but never really gets dealt with. I don't know of any case, I'm not saying it's impossible, where somebody's written to a video game company and said, I'm not going to agree to paragraph 3, subparagraph 2, but I'm willing to agree to everything else, and have gotten a response saying, that's fine. Maybe they would, and maybe it's worth trying, and maybe you should try it for one of your papers and see what happens.
I think if we ask some of the gaming companies, I'm assuming in-house counsel or lawyers, they would tell us if people have tried that before.
Well, we will have 2 counsel coming up from Microsoft later this semester from Redmond, and let's ask them. So let's table that. I'm sure somebody's asked, and I'd love to know what their instructions are in terms of a response. Maybe I'm crazy. But maybe if somebody tried a good housekeeping seal of approval on some of these contracts, maybe Creative Commons or the Electronic Frontier Foundation should actually have companies apply to them. And they say, you know what? This is within an acceptable standardized framework. Maybe they could raise a whole lot of money for their organizations that way. I don't know about you, but I'd feel comforted by that. I still wouldn't read the agreement, but I'd feel better about what I'm not reading. And then, I know it's a heavy word, but think about the morality of contracting out of the prevailing law of the land. Think about the fact that these agreements ask you to waive rights that you would otherwise have. So, I'll be brief to stay almost on time. First point is one that I've made several times. So to recap, you can interpret, understand, and rationalize many of the cases, read them, go through them, review these notes as being friendly to user rights and gamer rights. Specifically, I'll send you to MDY and Smallwood. Different observation, again, throughout this class. All of these contracts have all been different from one another, and even within the same company, the license agreements are different from one another. Each iteration that we've seen has had small and large changes. think about all of that in the context of, has there ever been a time in legal history when one type of contract is agreed to by billions of people? That's not one contract, but one type of contract. But certainly, the World of Warcraft agreement, even at 8 pages, it's got millions of people who agree. This is a very different, this is a different dynamic. And in fairness, this is not the same as going to rent a car and dealing with someone at the rental agency and having a physical piece of paper put in front of you and having the opportunity to look through it or not and being in a rush. It doesn't feel the same. Maybe it feels the same to you, and I understand the intellectual argument that it is the same.
It's kind of interesting, the whole notion of boilerplate and what its position would be, because that's essentially how the general public in general contracts has dealt with this in the past. If you're looking at a contract which is standardized, the one with the highest sort of formalities, you look back to succession, to your will.
Mm-hmm.
And when we have large numbers of elements which are, in fact, you have to go through to prove there's been a meeting of the minds.
Right.
And if any of that sort of is flawed, then that can be attacked and as the will is attacked. In the same way with any other contract would be there. And one of the interesting ironies, I think, that I see in most of these, you pointed out, all of these contracts are different, and they all change depending on the version as we go through. The more responsive the drafters of the EULAs and the terms of service are to whatever difficulties there have been, the less boilerplate one can have. The less boilerplate there is, the less you're going to be able to argue that, yeah, there was a meeting of the minds. The reason that we didn't bother reading all the way through is because we all know that it all says this. And the more they get into it and they muck with it, they change it. They haven't got it right by going to 8 pages. What they've done is they've come up with version, 7.6, and of how many hundreds. And all that does, I think, is that it allows for a potential to attack whether or not there's a meeting of the minds, the basic formation elements of the contract. And so I find it kind of intriguing.
Well, you've come to, in essence, the big finish. But I do want to just riff off one thing you've said before we put a capper on it. And that is that we as lawyers are very, and for all sorts of good reasons, complicit in this. And that is that we don't want to plagiarize other people's contracts. So when we're asked by a software developer, a gaming company, and I've done this a number of times, I will look at a whole bunch of precedents, but then I will do my own. And I'll change things, and I'll want to change the language. So I move further away from standardization because I don't want to plagiarize. I don't ever want to be accused of that. And there's arguments going on right now, as you guys know, as to whether lawyers' contracts and lawyers' arguments are in and of themselves copyrightable. And therefore, I don't want to breach having anything to do with intellectual property law. I don't want to be the one breaching intellectual property law in somebody else's copyright. So there is a deeper irony here. So to build off of Ken's point, what would happen if we didn't have license agreements? And I just want to remind you of a couple of things. All the cases we talked about, yes. Today we talked about the end user license agreements and the terms of service and the specific contractual terms. All of those cases had multiple causes of action. Most of those cases, BNet D being a really good example, other causes of actions, then the contract succeeded. So you usually had multiple pieces that gave the gaming company the remedy it wanted. So, are these contracts, are these license agreements references to Macbeth, full of sound and fury, signifying nothing? In support of that, for many, many years, Electronic Arts didn't have EULAs. And they didn't really get into terms of service until multiplayer became really big. And their legal view was that copyright law covered us well, thank you very much. And I don't know that they ever came to regret that. Certainly there's nothing on the legal record in terms of a case that they lost, that they wanted to win, in terms of dealing with a user or a gamer, that would suggest that they ever came to regret that decision. So I don't know how that changed. It probably changed because everybody else was doing end user license agreements, and somebody said, shouldn't we? And then the last point. Is all this redundant? And could it not be covered by IP law? And where is consumer protection law in all of this? And where is government regulation in all of this? And I'm a freedom of expression guy, so I'm not comfortable, as many of you know, with large parts of that question. But we are going to explore it in the third part of the course on controlling. And this is a little bit of a setup to that.